Okay, everybody say test. 1, 2, 3.
Test.
I heard 2. Yep. Okay. Okay. Are you right here then? Thank you, sir. Yeah. Okay. We are now on a new link. We posted the new link, but I'm going to put that on the other link in our chat area where I get a number of comments so that they're able to click over to us.
I got a message that they got knocked off completely. But it, says I got knocked off of YouTube and now it's just really.
Tell him to go back, he's putting it on our website, the new link. Tell him to go to our website and let it try.
What about people who
If they got knocked out, they should go back and also go back to the website and click in as well. And then here's Dave says, I can't hear anything, too much static. You know, what's that, and we have on the system this morning, we put the light on for us, basically, this morning.
And I cannot cut back in and it was a different link.
Okay. Yeah.
You can get our website.
And I changed the link already, but I had to come all the way out.
No, I'm not,
Also,
now I can't go back into
the
it.
people say they're on the website, you understand that?
I saw it on there, he's changed it.
Okay. Okay. Okay, I'll second, right? We're going to have board then, I can tell you you're. Like every other guy, man.
There's a lot of background noise.
Well, I guess because it wasn't heard before, I guess I'm gonna go back and reread the notice for the public hearing. Okay, so because this records it, makes it the legal document right here. So, please take notice, the public hearing will be held on December 4th, 2020 at 6 p.m. in the Berry County Garage, 14317 West, will be held out here in New York, 14411. The purpose of the public hearing is to consider adoption of proposed law number 3 of the year 2020, amending the state code, chapter 350, article 11 of the town of Berry zoning ordinance, referencing zoning and wind energy conversion systems. A summary of the proposed amendments is as follows. A, adding definitions for non-participating structures and participant structures, section 350-98. B, adding definitions for non-participating properties and participating properties, section 350-98. C, revisions for requirements for content and applications of wind energy conversion systems, section 350-101. D, revisions to application of new process, section 350-102. E, changes to standards involving setbacks, turbine height, noise levels for wind turbines, shadow flicker, and construction hours, section 350-103. F, additions to aircraft detection lighting, section 350 104. I'm sorry, that was lighting. 350-103. G, waivers for setbacks, noise levels, and shadow flicker for participating properties, section 350-104. H, additional requirements for decommissioning, section 350-105. I, amendment to standards for wind measurement towers, section 350-108. J, changes to penalties for violations of the local law, section 350-111. K, technical corrections. A full copy of the proposed local law number 3 of 2020 is available for inspection at the office of the Berry County Clerk, 14317 West Berry Road, Albion, New York, dated November 12th, 2020, Maureen Beach, Town of Berry, Town Clerk.
Sean, can I interrupt you a minute? Has anybody said they can't hear? I can't, all I'm getting over this one is mumbling.
And I just got a text from the resident saying that.
Well, that might be part of the problem with yours, is that if you're listening, if you're into the.
I'm into the YouTube setup right now with our
Yeah,
pictures.
you got a microphone right in front of you. If you got it muted right now?
Yeah.
Okay, because you were saying all you heard was mumbling.
I couldn't understand what you were saying. That's why I didn't know if anybody else could. That's why I was asking.
And this person said that they logged out and they tried to go back in when they're not supposed to figure it out.
That's your, please try it again, I've got a number here. have got you in, I can hear Maureen best.
I got 26 watching as
I'm
far as
having
this.
17.
I know. Maybe before, because of the telephone right there near me. Earlier, when we were having problems with it.
How many do you show, Carrie, you got? I got 26 watching, it says.
I'm not actually on YouTube.
17.
I just have people texting me.
17 you got, and I've got 27 now.
That's going to interfere.
I'm not, I'm just letting you know I can understand it.
Okay.
Um, So this person said that they went through the HUD and not through the town website, and so they would have been looking at the town website to get a new.
Yes.
Yeah.
Yes. You did post it. I got a comment here that says they could hear me quite well, and that we heard the 27 numbers, so.
Okay. I just turned the volume up on the amp there just a little bit. See how that works. Okay, moving on. Okay, due to the increase of positive cases of the coronavirus and the concern for the safety, health, and well-being of the citizens of Berry, the public hearing was changed from the town garage to a total virtual public hearing. I have confirmed with attorneys for the town that tonight's public hearing has been convened in accordance with the Governor's April 9, 2020 Executive Order 202.15 as extended by Order 202.79 to allow a municipal board to convene a public hearing via video conferencing or conference call through January 1st, 2021. The town is providing all interested persons of the public the opportunity to provide comments with respect to proposed revisions to the wind law via the chat function in the YouTube Live, texting to 590-6069, or email to spogue@townofberryny.com. This public hearing will be recorded and a transcript will be provided at a later date. I've done a roll call of the board members and there is a quorum present for this meeting. I have also confirmed with the town clerk that this meeting is being duly noticed by posting a notice of the town's bulletin boards on the front door, notifying the Batavia Daily News, and posting notice on the town's homepage of its website. A copy of the proposed wind law is located on the town's website under highlights, 8 bullets down. Anyone wishing to make comments or have questions may do so as mentioned previously. You must include your full name, that's first and last, and a way to contact you. At the close of the meeting, any further questions or comments may be sent by email, U.S. mail. You can fax it to our fax number here at 589-2510. That's fax number is 589-2510. Or you can place it in the drop box to the left of the front door. I received 2 comments today that way. All comments with proper identification, first and last name, pertaining to the proposed wind changes will be accepted up until the close of business on December 14th. Remember that this is a public hearing for and about the proposed changes to the town of Berry's existing wind law code only. Any comments pertaining to any wind company and or subsidiaries will not be considered pertinent to tonight's hearing and therefore will not be read or addressed. Okay. With all that read now. if we can, as it was outlined before, with the changes to the proposed changes to the law, and every member of this board has had them for months and months. I do have some comments here. I've received a number of comments, both for and against. Unfortunately, a lot of them have to do with wind companies and what it can or can't do for our community. I have gone through and marked up some of the comments, which I will read right now, where it does pertain to changes to the law, both pro and con, and most, but I will not read those components that are not related to the wind law changes. There is one letter that I've gotten 3 copies of, it's all identical, that was sent to me, and it says to be read in its entirety and recorded at the public hearing December 4th, as if I was presenting my opposition in person. I appreciate that, but there was only 4 points on here that pertain to the wind law changes. It says, "Dear town board members, as a resident of town of Berry, I am in opposition to the proposed wind law changes that are being brought before the town. I oppose the changes to the wind ordinance for the following reasons. It does not protect the environment or the health, safety, and welfare of neighboring property owners and the general public from any potential impacts. It significantly increases the potential aesthetic impacts by increasing height limits. It does not protect the risks of adjoining property owners. It does not properly regulate noise which can negatively impact adjoining properties, since it does not adhere to current World Health Organization guidelines or norms." And these I received from Nancy and Annette Blank, and Alan and Marcia Dess. Another one I have, mostly, there's a number of them here that were written by a number of people. The only problem was, I will only address the last paragraph. Says our hope is that the town boards will work together to show that we elected them to be our voices and to think for all residents. We urge you to revise the wind ordinance to New York State standards. Another one, the Berry Town Board. I realize the changes to our wind ordinance would have to be made. When our initial wind ordinance was created, there were not turbines as tall as the proposed ones. Technology has changed since then. I do not see the difference in height as an issue. In fact, there will be fewer turbines because of it. Technology changes all the time. I actually like the fact that Harlan Town could be part of making the world better. Let's make an effort to make a difference. Another one. That one was from Kelly Dunn. Like I said, the one previous to that, in support of changing the wind law, there was numerous, there was, I don't know, 30 some odd copies of the same one. Okay, this one, I am registering my opposition to the change of our zoning ordinances, and the rest was directed towards the wind company. That was from Dan Snyder. Next one. Lisa Burleson had 3 votes on here, but only one of them pertained to the wind law, and it says that the new proposed height of the turbines, this affects the visual impact at a greater distance, possibly reaching into the town of Albion. Have all homeowners been contacted or surveyed for whom this will now affect? Chris Younger. We are certainly in support of the new wind ordinance that you will be discussing tonight. Please let us know if we can give any assistance. Thank you for your hard work on this issue. We appreciate all the decisions your elected officials have to make. This one's from Chris Loss, to the town of Barry. I am writing to express my support for the change of the town of Barry's wind ordinance. I believe that the proposed changes will allow the turbines to be built responsibly and ensure the safety of the residents. We have to make sure our grandchildren have a planet we can live on and green energy is necessary. As I said, there was a lot more to those, but because they were pertaining more to specific company, not about the law, that's why I have not read the whole thing. I do have one here from Andrea Reba, which is a very good one, that she wrote. It's 2 pages long, small font, and it does have to do with all the different components. She refers to every section in the town law. And I think that this might be one, I don't know, Mr. Mark, should I just put that in with comments in, rather than reading the whole thing?
I would
Or
think,
should I read the whole thing?
no, I think that would be appropriate.
Just making, because everything I have read so far will be typed up and put
Right.
in as well. So I'll do the same thing, but like I said, Andrea said, she did go in the depth, and she went to all the different components. So I give her kudos for the work that she put into this. It does not have anything to do with any wind company, just the wind law and the Strickland government. Okay, what do we got here? Okay, let's see.
I got a message that they can't hear the phone.
Here, we haven't done anything with the codes.
I'm just saying.
Yeah.
It sounds like it's fading in and out on you, Sean. We get one saying it's good, we get one that you can't hear, and the comments coming in.
On which item now?
I'm on the YouTube. The comments are coming back on that, and I'm reading.
Yeah.
Just got one here. Phone audio is clear, so I think it's working well on the phones. We've had a couple freaks saying the phone is
Back here,
clear.
this person says that everybody sounds great except me. That's understandable.
I've got a message here that says the phone audio is fine. And the order from the governor basically says that it can be done via video conference and or telephone. It's not both, it's and or.
I just received 2 more that were put in the Dropbox. It's the same code there before, where I just got the 4 bullets out of it. Opposing the changes of good ordinance for the following reasons. As I said, I read the 4 bullets on it. These are from David Waters and Rhonda Waters. And they'll be added to that, those other ones. Okay, with that. My mic is turned on. Jack's plugged in, so we only have the 4 mics and all 4 are plugged in. Okay.
I received 2 emails today, so
As a hearing without being able to hear doesn't seem to be very public. I got no complaints on the phone. All I do is it can't hear me on my microphone.
I got another text message after I shared that, it says it's not, it's too far away, I can't hear it, and I volume is all the way up. From someone on the phone.
On the phone?
Yeah.
Phone's right in front of me, they cannot hear me.
The ones I'm referencing, it's similar to the one where we got one from the top. And there's the heated top, and then there's, another one, that has, from their family.
But
Has the name on it.
I just got another message saying the phone is still and has consistently been good.
okay.
We got one here, Sean, that somebody was asking how to hook into the phone. You might want to give them,
Okay, to get the call in on the phone so you can hear what's going on. And because we are giving 10 days for comments, questions, whatnot, and then we will post those until December 14th. So if you want to go over to the phone, you need to call the town hall at 589-5100. When you start to hear the greeting, push number 5. It will then ask you for your PIN number, in which case you will push 4321 pound. And that'll tie you into the meeting here on the phone. That you will find one other and 2 screenshots. Please give them consideration. Okay. And what we gotta do is start then to work on what purpose is being here. Is for that. One screenshot sent to us by Darrell Sanford.
Yeah. Look at you.
Yeah. I just wanted to see.
This is all you need.
Getting my thoughts done.
Yeah, mine is right here.
Okay. This is, this one has real-time fuel mix as the title. We've got a comparison of real fuel versus renewables. Once again, it's not part of our review. Everyone, I mean, we're taking into consideration down the road, but right now, we're only talking about the wind loss. Second screenshot, daily fuel mix photos. That shows fuel, wind, hydro, other renewables, fossil fuels, some of them, once again. Doesn't have anything to do with nice wood. And then the last one. Okay. I have a feeling that it's probably related to the other ones with all the other energy showing comparison of usage. So, going back to the proposed wind law changes, questions people have, if you are on YouTube there. Okay, I'm not directly into the microphone. I can't get any closer to the microphone in my hand right now. Okay. The changes, as we have stated in the newspaper article. Anybody that has a question about or a concern, adding the definition for non-participating structures and participant structures as in section 350-98. 350-98. So she's opposed to wind ordinance changes as written. I am blue arrow. I'm equally opposed to how this public hearing is being conducted. You cannot hear the public, and the public cannot hear you.
I've not been able to
Oh, I know you're not going to go to
No,
No, I was not, because it is very lengthy.
but it's certain,
It is pertinent, and that's what I had said, right here. I said, this will be published with all the others, and she is very good with everything that she put in here.
and then you asked him if he could read it, and he said yes, and he doesn't have to.
Well, I think he asked me if it would be added to the record, and I said, yes, if
Put it into the record.
you feel that it needs to be read in full, then, by all means, read it in full.
Okay. Oh, we didn't put it, Gary. You're very welcome. This communication, this is Commander Reba. This communication is to notify you that I am opposed to the passage of local law number 2 of the year 2020, which proposes to amend, repeal, and supplement the Town of Berry zoning ordinance, chapter 350, referencing zoning and wind energy conversion systems. The existing law has flaws that need to be addressed, but the proposed changes to this law not only fail to address those, they appear to have been created to tailor the law to the specific project that has been proposed. They completely fail to provide protections for the health and welfare, both physical and financial, of the people living in or owning property in the town of Berry. Among the shortcomings of the proposed law, the most egregious are the following. Number 1, this is critical omission, tip pipe. It is referenced many times in 350-101.6, 350-103.1, H, 1, 2, and 3, 350-103.6, but it is not defined. Section 350-98, definitions contains only this reference to triple pipe. Tower height and or total height. Tower height is equal to the distance from the ground to the top of the tower, not including the nasal or rotor blades. The italics are in the original document. This definition gives the impression that tower height and total height are synonymous. They are not. All parties who deal with the WDCS recognize that the total height of the turbine is measured from the ground elevation to the top of the tip of the blade to the apex of rotation. The size of the turbine is a major factor in determining the detrimental effects on those living within several miles of its location. There is also an odd typographical error in 350-103.6. This paragraph is indented further than number 5 and 7 above and below it, respectively. Would result that one might miss this vital requirement if one were not careful. The paragraph gives an imprecise definition of how to measure tip height. Such vagueness must be eliminated, and the proper definition of total height be given in the definitions section. Now, this is dated September 28, 2020. Our final copy.
Tip height was always part of the definitional section.
That's what I thought. We had it in there.
Yes. It's right above the definition of tower height and or total height.
Right here, tip height. Tip height is equal to the distance from the ground to the tip of the rotor blade in a full, upright, vertical position. We're not talking about the old, we're talking about proposed changes. So, in essence, we're addressing what she said. So there, thank you very much for that one, we got it. Number 2, the increase in total height from 500 to 700 feet is obviously a concession which wishes to use a turbine that will be approximately 680 feet in height. Such a drastic increase in height provides no benefit for those who must live and work among these machines. It is indicated that such tall machines intended for areas with light air in order to maximize energy production. This is an acknowledgement that the wind resource in Berry is inadequate or inefficient for an efficient WDCS. WDCS, for those who might not know, that stands for Wind Energy Conversion System. The town of Berry should not have been selected for a WDCS in the first place. Its choice apparently was based more on a client population with cooperative town officials than it was on technical issues. You can't even address that one right there. That's one way of putting it. 3, inadequate setbacks put residents in greater danger of harm from noise infrastructure, effects, shadow flicker, fires, ice growth, and the visual disturbance of having to view giant whirling machines from their homes. And that has been moved about town. Larger setbacks are needed if Barry is to avoid the problems now plaguing other New York communities that operate with WECS. Okay? That to me is an opinion. That's a concern, yes. And I think we went gone through, we have stricter setbacks than what the state is even asking for.
That's, just to amplify what you're saying, that's correct. Under the new Article 94C provisions, the setbacks, just so I can read them, public roads 1.1 times the wind turbine tower's height, property lines 1.1 times, non-participating non-residential structures 1.5 times, non-participating residences 2 times. So I believe our setbacks are in fact equally or more restrictive than that. The same thing goes for noise and shadow flicker. Shadow flicker under the standards that are now being established by the state calls for 30 hours. Ours is 25 hours. The just to address it, because I'm sure it's going to come, noise. The state standards are 45 dBA LEQ 8 hour at the outside of any existing non-participating residence, and 55 dBA LEQ 8 hour at the outside of any existing participating residence. Ours actually includes a reduced noise level at night for non-participating residences of 40 dBA LEQ. So it appears to me that our standards and the proposed changes actually are more restrictive than the standards that the state is putting forth.
Okay, as you pointed out, we are either equal to or more stringent than what the state is recommending. And those were even from 2008, as well as a couple of proposed changes we just made. Okay, failure to correct measuring the setbacks and building the property line restricts residents' ability to enjoy all parts of their property. This may even be seen to be a taking. Okay. Reduction of property value. So that was not hosting a turbine on their property. This is a complex issue which will ultimately affect every property owner in town. But the immediate loss of value loss caused by the construction and operation of the wind development will be felt by the non-participating properties. A fair law would provide protection for such property owners. 6, the noise limits proposed in this law are woefully out of date. They are those favored by the wind industry, but not by the New York State Department of Health, Western New York Public Health Alliance, and the boards of health for Orleans and Niagara counties, who consider such high limits to be detrimental to public health. The town's ordinance must be updated and conform to the latest research and requirements in this area. Perhaps it should come as no surprise that the proposed revisions to this law. I'm never really further with that because it's referring to a specific company. Refusal. It appears that most of the individuals that are speaking in favor of changes to are those who stand traffic permit in some way. If the project affected them only, it would not be anticipated. Okay, we're in the project again. Okay, the rest of it all has to do with benefiting or not benefiting from a wind project in the town and not having to do with the law itself specifically. Okay. Okay. Now, and I do not, okay, so, should be from the property lines, not residences for any reason. Residents should not be mentioned or they do not sit on a property line. A person has a right to use every part of their property, that's from Tom Chandler. The same applies to sound, reading should be taken at property line, which from Tom Chandler. We are looking at them, and anybody on the board can chime in, not just me. We look at making sure that it's non-participants versus participants. And we want to make sure that they have a comfortable sound level. We want to make sure that they are not anywhere near anything that could possibly go wrong with a wind turbine. So therefore, it's a greater setback and lower sound level, decibel level for non-participants than it is for participants. Not just a property line, because to a property line, you can't stop anything from a wind turbine, you can't stop the sound level. So we look at how that affects non-participants as well as participants. And the participants, because they've signed leases, are more accepting of. They are more willing to have the larger limits. Am I incorrect?
No, that's correct.
That being said, though, the way that the proposed changes are, it is 2 times the setback from the resident, 1.5 times the setback from the property line. And the noise is from the resident, the commercial building, but it's not from the property line. And I think that what Tom was saying is that it should still be from the property line.
May I say something?
Sure.
I mean, I understand the position, but the idea here is the reason for the noise level is to prevent disturbance to people in their homes and in their buildings. And it has nothing to do with a property line. So it's considering, the setbacks are considered to take into effect 2 things. One is safety, in case, and it's a very remote possibility that one of these turbines would fail and fall. And then the next thing is to ensure that people who are in their homes are not affected, that the levels are below what have been determined to be nuisance levels. So that's why it talks about a distance, the setback is not less than 2 times the tip height from any existing residential or commercial buildings. And that's regardless of whether it's a participant or a non-participant. And then also 1.5 times the tip height from the property lines of any non-participating property. So, I mean, there's a two measurement process here. 1.5 times the tip height to the property line, from the property line of a non-participant, and in addition, 2 times the tip height to any building, regardless of whether it's residential or commercial, and regardless of whether it's on a participant's property or a non-participant's property.
Well, Can I, so what you're saying, if we had a property that, I chose to subdivide my property, for example, and I was gonna subdivide my property and build a new parcel, or a new building, a new structure. If that new structure is too close to the windborne, or to the industrial wind turbine, based on the sound setback, I would be, as a resident, prohibited from building based on our zoning and our ordinances, and that it would inhibit my ability to use the property that I have because the setback is not based on the property line, because the setback is based on the resident or a business, if I wanted to build a business.
Well, I mean, I understand what you're saying. The thing is, once you have the law in place, all right, just like any law, any zoning law, people have to, I mean, they're either aware of the law or they should be aware of the law. And if they want to create a condition after the fact that is not, consistent with what the law provides, I mean, they do that kind of at their peril. It's sort of like, if we passed a law that allowed for, I don't know, milking parlors and manure smell and, a right to farm situation, and then somebody moves into the area after that and complains about the smell, I mean, they do so at their own, I don't want to use the term at their own peril, but they do so with advanced knowledge of what the situation is. So, could it affect a subdivision of a property, for residential purposes? Yes, it could.
But when we have residents who are expressing this concern, I think that this is something that we should take seriously and not just dismiss, that we should say that is a legitimate concern, a legitimate reason to make sure that we're looking at this and not just saying, oh yeah, okay, that's fine, because this is something that could potentially directly impact them and their use of property that they already have prior to any proposed project coming in.
Well, I guess, I don't know how you alter that. I mean, if the turbine is 1.5 times the tip height from a property line, is somebody gonna, how is that property line gonna shift? If you're gonna subdivide, it would seem to me you'd be taking a smaller parcel out of the existing parcel. So let me finish, please. So the 1.5 times the tip height from the property line, that wouldn't change.
You're right, that wouldn't change. What I'm talking about is the sound. And what he referenced, he also referenced the setbacks for sound and because there are differences. So from the residence, we have the 2 times, from the property line, we have 1.5. Then you subdivide, and the sound distance is solely based on the residence rather than on the property line. And that's the way that it's written in the proposed law. So that would change. So if you wanted to build, maybe farther away from the road or back into your property more, then you could potentially not be able to do so because of the sound impact.
I can't think of a specific instance. I understand what you're saying, but I can't think of a specific instance if we're talking about constructing within a boundary of an existing lot or a subdivided lot that's within the existing lot. It would seem to me that unless somebody deliberately wants to build their house or something closer than 2 times the tip height, they're doing that in derogation of what would be the law at that point and what the zoning provides for. So presumably, I don't even know if they would even be able to get a building permit for that.
So you're focusing on the setback based on the distance setback, and I'm talking about the noise setback. And when we're referencing the noise setback, what I think that there would be an easy solution to that, which would be just to have it be from the property line and not from the structures.
Right.
Because that would protect the landowner and their property, is what I'm saying.
And as Lance had pointed out earlier, that based on what the state says at 1.1, we are having greater setbacks than what the state is proposing.
Well, we have the same setback as what the state is proposing based on the, and that, the non-participating 2.0 times the setback. So that's actually the same as what we, for the residents.
Well, I'm looking at the setback standards right now. It says 1.5 times non-participating, non-residential structures. And we are at 2 times rather than 1.5 times. Property lines, they're at 1.1, we're at 1.5. Public roads, they're at 1.1, we're 1.5. So
I have written down 2.0, but maybe I'm.
I'm looking, this is section 900-2.6, exhibit 5.
And these, all of these standards have been fully ratified?
I'm sorry?
The sections from the 94C have been fully ratified and have been approved and
It's in the legislation, yeah.
but it hasn't been approved.
Yes, yeah, it has. There are regulations that are still pending, but these aren't part of the regulations. This is actually part of the actual 94C legislation, which has been passed and which is in effect.
Okay. On Taylor Road again, why shouldn't I have to tolerate a high sound while we're enjoying my time? If 2 times is required from a home, it should be the same from a property line. And next on a weekend camp out at times, a 10 becomes my residence. I don't know. The residence to me is not a temporary like this, like pulling a trailer with my motorhome. It would be a residence that I could have a legal address, I would dare say. But we have to have a residence or a business.
So you've been building everything using the property.
We can use this property, you know. I'm not saying you can't.
So you're saying that the sound level there doesn't matter.
And I thought the hearing is to gain information, not to give it.
It is.
Well,
It is.
because nothing's gonna be decided tonight, nothing, this is,
There's nothing information.
it's all we're doing.
Concerns. Anybody else got anything? I keep watching on the live chat right here. I don't know who this is from. All I got is a phone number from Verizon. So like I said, I do need a person's name, so I'm not going to even address it because I don't have a name to them. So if you're still listening to whoever it is, if that's your name, that will do it.
You just reply to them with that.
Well, obviously, that's good.
Because I don't know what that says,
Can I just also point out under noise, this provision, subdivision D, which I think might answer Carrie's question, but it says, in the event that the ambient noise level exclusive of the development in question exceeds the applicable standard given above, that is, those specific DBA standards, the applicable standard shall be adjusted so as to equal the ambient noise level. So in other words, if, regardless of wind turbines, if the ambient noise level is 35 dBA LEQ, and so now you have a total of more than that, all right, this is saying that the standard, which we have up there under subdivision 2A, that standard gets reduced, so it's no greater than the ambient noise level. In other words, you don't have greater noise than what would have existed prior to the turbines going in.
So how would a resident know what the ambient noise of their property was prior to, and how would they be able to establish?
Well, it says in here, I mean, that there have to be measurements taken. Ambient noise level should be measured at a distance of 1,000 feet from the base of the wind energy conversion unit. Ambient noise level measurement techniques shall employ all practical means of reducing the effect of wind-generated noise at the microphone. And then it goes on for other things, but
But that would be saying, right, that the property owner would have to be able to establish what the ambient.
no. I mean, that's up to the developer to do that. I mean, as far as determining what the ambient noise level is prior to the commencement of construction.
No, so say, for example, in the situation that Tom brought up, say that he had a pond he was using, and then he goes back and he wants to test that he can't put at his pond for the weekend. And he gets back there and the noise, he can't tolerate it. So he puts in a complaint. What's to say that the developer doesn't just say, well, that was the ambient noise level prior to.
Because those readings have to be done in advance of construction.
But they're not going to be done at every residence or every location, only done in specific.
No, they're going to be done at 1,000 feet from the base of the turbine.
So what you're saying is that the noise levels are from 1,000 feet, not from the residence. It's not, it's.
1,000 feet is less than what we're talking about as far as setbacks.
But
if the tower is 680 feet, if the tip height is that, so 1.5 times that is over 1,000 feet already.
But what I can share with you is that it's actually based on the turbine. So one of the individuals that I spoke with that actually operates the industrial wind turbine down in Texas, the California Nation Turbine, he was sharing that their setbacks, there's only one of them, so their setbacks aren't necessarily that great. But he said that if he was to be looking, he said any downwind, he said it's actually a half-mile distance is where the noise complaint come. It's not 1,000 feet, it's actually a half mile. And this is from someone who is in the industry and shared that if he was working on a wind ordinance, he would have a half mile setback from downwind locations specifically, because it's just based on the way that the wind travels through and the way the sound carries.
I don't know how to respond to that. I mean, I haven't.
You haven't been writing?
I can call him back. It was a phone conversation. I didn't have it, but I can call him back.
I'd like to see that documentation. Two messages that I did receive. Okay, this one says, please let people know that you can stand in their turbine and hardly hear it. They always probably have wind here. This is Alex Napa. What are the recommendations of a manufacturer for turbine for setbacks? I've never had a fence for it.
I haven't either.
That's a good question.
No.
I forwarded it in my email so that I can address it later. I actually don't know, but Alex, I wouldn't talk to you about that.
Can you repeat that question, please?
What are recommendations of the manufacturer of the turbine for setbacks. Okay, is there anything else? Let me go back over to the on screen. Let me give you my emails. A lot of comments, but nothing pertaining directly to the changes to the wind law. Nothing from anybody else here? Well, I think that's about it. I don't have questions pertaining to it. I don't have anything more to read more people by. A reminder to everybody, at the beginning of this second session, I have said that you have until December 14th to get that information, any questions or comments about the wind law proposed changes, please send them into us. Email by drop box outside to the left of the front door, to our fax machine, which is on our website. I'm trying to find my sheet. Obviously, it's not there yet. So you keep a number, you can't find it there.
2510.
5510,
2510.
2510. 5810, 2510 is our fax number. You can send it to the fax. So once again, that's email, fax, U.S. mail, or the Dropbox, but by the close of business on the 14th of December. Okay? Any questions? We all set here? Then I will call this to a close at this time. Thank you very much, everyone.
I don't know if you need a formal motion to close the public hearing, so
We do?
I think you should probably.
I so moved that we close it.
Okay.
I'll second
All in favor?
Aye.
Opposed? So carried then.
Do you want these back?
No, that was a special one. I ran off just for you.
Oh, thank you.
Go to with your other 20.
Yeah. Well, we still have a town board meeting on the 9th, correct?
Yes.
Okay.
Next Wednesday.
Okay.
Or this coming Wednesday, I should say.
I was gonna get a trailer and put it on the lot next to the town